Hello everyone, my name is Abby Zamudio. Group 10 Civil Liberty Project is presented by Giselle, Jolie, and I on a topic of equality and other groups. Equality has been a prevalent issue since the dawn of time. Our nation has been, since to this day, fighting to ensure that everyone, regardless of race, gender, color, religion, and national origin, is treated equally. Subsequently to the Civil War, congressional reformation included the 13th, 14th, and 15th Amendment. These amendments were also known as the Civil War Amendments. It is designed to ensure equality for recent emancipated slaves. However, the 14th Amendment, which granted citizenship to all born or naturalized, including formerly enslaved, and equal protection under the laws. The 14th Amendment is considered a landmark of the legislation. It not only protected the rights throughout the nation, but also supported equality as a constitutional value. A year after President John Kennedy was assassinated, Congress passed the Civil Rights Act in 1964. The provision prohibits discrimination based on sex as well as race, color, religion, or national origin. It prohibits discrimination in public accommodation, public property, or public schools, government agencies, and employment. In addition, it enforces voting rights and desegregation of school. The Civil Rights Act is considered one of the notable achievements in civil rights movement. So what is ERA? ERA stands for Equal Rights Amendment. It's an amendment that would guarantee to protect women and other marginalized genders directly into the United States Constitution. When the Equal Rights Amendment was passed by Congress in 1972, it was a culmination of a fight that had already lasted nearly 4 decades and is still far from over. ERA was not ratified back in 1970 and 1980s because the legislation included a 7-year deadline. After the deadline passed, it was 3 states short needed for ratification. Currently, ERA has finally been ratified by the 3 final states. However, final steps are needed to examine, to certify, and publish it as a 28th Amendment to the U.S. Constitution.
Civil rights cases are a very significant area of law that the U.S. Supreme Court has encountered on many occasions. From race and gender discrimination to sexual orientation discrimination and struggles over disability rights, some court decisions have supported and broadened equal rights, while other decisions have restricted them. Dred Scott versus Stanford, 1857. This ruling established that slaves were not citizens of the United States and were therefore not protected by the U.S. Constitution. After living with their master, an army surgeon, in the Free Territory of Wisconsin, Dred Scott and his wife Harriet fought for their freedom in Missouri, a slave state. Scott was defeated 7-2 by the court. The judgment nullified the Missouri Compromise, which had barred slavery in the territory. The Dred Scott judgment was later overturned with the passage of the 13th Amendment, which abolished slavery in 1865, and the 14th Amendment, which granted citizenship to all Americans born in the United States in 1868. United States versus Windsor, 2013. In 2007, Edith Windsor and Thea Spear married in Toronto. The union was recognized by the state of New York where they lived. Because their marriage was not recognized by federal law, Windsor was required to pay $363,000 in estate taxes when Spear passed away in the year of 2009. The 5-4 victory in favor of Windsor was decided by the court. The Defense of Marriage Act, which defined marriage under federal law as a legal union between one man and one woman, denies same-sex couples who are legally married under the state law of their rights to equal protection in accordance with the Fifth Amendment. Bostock versus Clayton, 2020. In the major 6-3 victory, the Supreme Court authorized in Bostock versus Clayton County, Georgia, that the 1964 Civil Rights Act's protections be extended to include members of the LGBTQ+ community. Discrimination against LGBTQ plus individuals in housing and the workplace was ruled to be unlawful as a result of this court's decisions. Loving versus Virginia, 1967. Marrying in Washington, D.C., 17-year-old Mildred Jeter, who was a black woman, and her lover, who was a white 23-year-old man named Richard Loving, returned to their home state in 1958, where the couple were charged with unlawful cohabitation in jail. The married couple departed Virginia and decided to live with relatives in Washington, D.C. After their arrival from visiting family in their home state 5 years later, they were arrested for traveling together. Following along and taking inspiration from the civil rights movement, Mildred Loving decided to take a stance and wrote a formal letter to Attorney General Robert F. Kennedy for help. The couple was then referred to the ACLU, which represented them in the landmark Supreme Court case. In favor of Loving, the vote resulted in a 9-0 ruling. The court's decision ruled that state bans on interracial marriage was unconstitutional and decided to abolish all state miscegenation laws.
All right, moving forward, we've got executive orders and legislation pertaining to equality. First thing, we've got Executive Order 11,246, otherwise known as the Equal Employment Opportunity. This was signed by President Lyndon B. Johnson on September 24th, 1965, and it required employers to execute non-discriminatory practices during employment as well as during the hiring process. So this was under government contractors only, and it prohibited discrimination on the basis of race, creed, color, and national origin. Then we had Executive Order 11,375, also signed by President Lyndon B. Johnson on October 13th, 1967. This amended Executive Order 11,246 and banned discrimination based on one's sex during hiring and employment for the U.S. workforce and government contractors. Then we have Executive Order 11,478, initially signed by President Richard M. Nixon on August 8, 1969. This banned discrimination in the competitive service of the federal civilian workforce on the basis of race, sex, color, religion, national origin, disability, or age. Bill Clinton then went on to sign Executive Order 13,087 on May 28, 1998, which amended Executive Order 11,478 and added sexual orientation. Obama then signed Executive Order 13,672 on July 21, 2014, which amended Executive Order 11,478 and 13,087 and added gender identity. Then on January 20th, 2021, Joe Biden signed Executive Order 13,988, which commands all federal agencies to review their programs, policies, and regulations that regard the prohibition of discrimination based on sex and gender identity. Then we have, moving on to legislation, the Civil Rights Act of 1964. This passed under the Johnson administration and outlawed discrimination based on race, religion, color, or national origin. It applied to schools, the workplace, and other various public settings. The bill did not initially include women, so it helped propel the women's liberation movement. We later had Title VII, which added an amendment that did include women, and it banned employment discrimination on the basis of sex, along with race, color, religion, and national origin. Then we had Title IX on June 23, 1972, that prohibits the discrimination on the basis of one's sex and any education program or school setting that is the recipient of government funding. Then we had the Pregnancy Discrimination Act of 1978. This banned discrimination against pregnant individuals in the workplace, said you cannot discontinue employment or refuse to hire somebody due to their pregnancy or pregnancy symptoms. Unfortunately, this was a very common occurrence before this point, so this was their efforts to stop that behavior. Then we have the Equal Pay Act of 1963. This illegalized paying women less than men for the same job based on their sex alone. So I'm not saying this was entirely foolproof or fully effective, but it gave women a way to fight back. So women can now file a claim against employers if they feel like they've been subject to unequal pay based on their sex. And that's going to wrap it up. Thank you so much for listening.